Good afternoon, folks. We have, I'm told, 7 hours of argument time. Given today's special day, that's less time to go trick-or-treating for treats, so I'm not so sure we're going to want to do that. So I ask you to ask for the time that you need to make your point, and then just so you know, we've read the record, we know the cases, so we can proceed from there. That said, first case up on the calendar, let me just get my notes out here. People versus LaShawn M. Oh, off to a good start, submitted. Second case on, Franco versus 71st Street. 5 and 2. What? How much time you want? You really don't want to go trick-or-treating. He said 5 and 2. I'm glad it's fine for you. 5 and 2 and 5. Thank you. Third case, Joshua A. versus Shaquanda T. Submitted. Simungo versus New York State Department of Financial Services.
Good afternoon. For appellant, Antonia Casulas, 10 and 2.
Respondent requests 5 minutes, Your Honor.
Okay, it's 5 and 3 and 5. Just so you know, the time that I give you doesn't mean it's an absolute stop for you, but not for us to continue to ask you questions. So don't be concerned about that. So next case, Kelly versus City of New York.
Lord, for the appellant, 5 and 2, Your Honor.
Okay, 5 and 2 and 4, thank you. People versus John Bonet. That's a submit. Stagen versus New.
Appellant 6 and 2. Respondent versus Your Honor 5.
6 and 2 and 5, thank you. Casafatori Limited versus Portavosi.
7 and 3 for appellant, Your Honor.
For respondents, 5.
And we'll give you 5 and 3 and 5, thank you. Lee versus 33 Captain Claus.
Robert Basil for plaintiff. Appellant 7 and 3. Richard Paula for respondent. 5 minutes, Your Honor.
Okay, 5, 3, and 5. People versus Dari Ramirez. Oh, that's a submit. Counsel, you're gonna have to wait. Whoa, hello. Sorry. It's not a wedding, you can't just walk up and leave. So we got to submit on that one, thank you. Moises Ortiz versus FDB Acquisition, that's 11 and 12, that's on.
For 11, RNC Industries, the appellant, 5 minutes to rebuttal.
You said 5 and 2?
Yes, please.
For the respondent, Your Honor, 4 minutes.
4 minutes? Great, okay. I mean, it's pretty much, I mean, we know what's going on here, though we got 2 cases. Okay, 5 and 2 and 4. Oh, he's going to submit on the other one. Oh, okay, so that's number 13. That's the FDB acquisition. That's a submit.
I'll submit on that one.
You're going to submit on that? Okay, that's a submit. You got that, folks? Okay, great. Yeah. Submit on that? Okay, that's a submit. You got that, folks? Okay, great. Yeah, all right. Ambase Course versus 111 West 57th Street.
Appellant 5 and 3.
Respondent 5.
Thank you. 5, 3, and 5. I'm probably the only judge that hasn't sat on this case yet, of this bench. Interesting. All right, Rodriguez versus Sewell. That's a submit. Cousins versus Glover.
Request 3 minutes.
You're by yourself. You want to submit? 2 minutes. Okay. People versus James Glenn. 6 and 2. All right, 5, 3, and 5. We have Madison Square Garden versus New York State Liquor Authority. 7 and 3.
Anthony Rodolfo on behalf of the state respondents, 7 minutes, Your Honor.
7, 3, and 7. Okay, 7, 3, 7. Got it. Okay. First case up. There's my notes. Go to is Franco versus 70. Is that right? Franco versus 71st Street, Lexington. Okay.
Good afternoon, Your Honors. Matthew Ullman on behalf of Appellant, 71st Street, Lexington Corp. The lower court's order should be reversed for 3 independent reasons. First, the order improperly held that the 2019 dismissal order extinguished the counterclaims, which were never adjudicated in the 2000
Why did you wait so long
on what,
moving
Your
for
Honor?
attorney's fees?
Well, we did not wait per se. The dismissal order never actually extinguished the counterclaims.
But when was it entered, the dismissal order?
January of 2019, I believe, Your Honor.
And you brought this motion in,
We brought the cross motion after, so my firm was not involved.
that doesn't matter. it's your
Irrelevant,
client.
I understand, Your Honor. But when the respondent brought the claim for,
And
the
when did you
2013
cross-move?
what's that?
And you cross-moved,
And I cross-moved.
and when was that?
2022.
So why did you wait 3 years to seek attorney's fees after the dismissal order? That was my question, to which I'd still like an answer.
Yes, Your Honor. The reason that the claims were not brought initially were because it was unclear at the time as to whether or not the dismissal order actually dealt with the relevant counterclaims.
But the order had the case marked disposed, which meant that the case was over.
Yes, and under 3019D2, that dealt with the underlying claims, Justice Mendez, on the complaint, which is clear on the record on page 97 that the dismissal order actually dealt with the complaint, which was the only adjudication and the only request that were sought initially by the appellant. In holding that the failure to annex the reply into the dismissal order was the only point in which the lower court in the dismissal order actually adjudicated as to what, I'm sorry, did not adjudicate, but actually held in dicta that the counterclaims, or that the 2013 and 2014 so ordered stipulations and the ejectment order of Justice Billings rendered the counterclaims somehow moot. But of course, that was never in front of Justice St. George. That was really only in response to respondents' claims that, in fact, the failure to include the reply was somehow rendered the motion itself, should have rendered a denial of the dismissal claim. Of course, that makes no, that was the lower court had ultimately determined that the complaint.
Was there any obligation on the part of the plaintiff to give you notice that you kind of was sleeping at the wheel?
I'm sorry,
Was
just
there
so,
any obligation on the part of the plaintiff to give you notice, to serve you with a demand notice because you guys somehow, the prior counsel was not doing what they should be doing?
of course, and that's the entire point of the 3126, is that if the counterclaims themselves were never adjudicated, which they weren't, the court cannot sua sponte just deny on that basis.
You're saying 3216.
I'm sorry, Your Honor, I did miss.
Yeah, but 3216 is not applicable because it's not dismissed in a way for failure to prosecute. You simply took more than a year to try to enter a default on a counterclaim that would not reply to.
Well, in fact, Justice Mendez, if I may clarify, the reply, it's really not disputed here that there was a reply filed in this action. Unfortunately, this was a pre-NICEF case, and so the reply was actually never part of the electronic record. There was, in fact, a reply here. So the point in which justice or the lower court held that in fact we had failed to include a reply is actually not true. In fact, it was counsel for respondent who in fact served the reply way back in 2013 before this action was e-filed. And the lower court actually handles that to a degree, Your Honor, because he does not hold strictly and end the decision at there should have been a reply and there was no reply, and therefore it's denied.
In any event, did you support your cross motion for the counterclaim for fees with the usual, and I mean in a good way, bag of tricks, like an affidavit with someone with personal knowledge, the bills, the invoices, the typical paper trail that would allow a court to determine the basis for your fees, the reasonableness of those fees? There's nothing on this record that you did that, correct?
I mean, no disrespect, Justice Oeng. I see that my time has come. May I please answer?
Yeah, you can answer that. Thank you.
Thank you, Your Honor. Justice Schulman, if I may, at the time that the cross motion was made, all of the underlying causes of action on the actual action were actually sitting sub judice.
So is that a no to Justice Schulman's question? You didn't submit them?
We did not submit them. However,
It would help to start with that.
yes, Justice Kessler, I apologize.
Oh, okay.
No.
I got it. We got it.
Thank you, Your Honor.
You have time on rebuttal.
If it pleases the court, my name is Maurice Heller of the firm of Foster Garvey PC, and I'm here for the respondent. We've heard a lot of excuses just now, but getting to the substance, you really didn't. And the reason is because the two excuses that they offered in their papers, which are not acceptable as far as we're concerned, is A, that the discussion of mootness in Justice St. George's order was dicta, and B, that the entry of a final disposition was a mistake. That's pretty much their argument. It could not have been dicta because there was a ruling behind it which basically denied part of the opposition or granted the motion that was being decided on the basis that the counterclaims were not included. The court ruled that those counterclaims were moot. Now, mootness is a substantive ruling. That disposed of the counterclaims. Secondly, when a case is marked disposed, it was fully disposed here. There were not any indications that there was anything left in this case. It was over.
But it was true that at that point, no judge had ruled on the counterclaims per se, correct?
Well, the judge did rule in that they were moot. And that was called for by the opposition that demanded that they were required to annex their counterclaims as part of the motion.
Which would lead to the next thing is that after getting that order from Judge St. George was to either move to re-argue or appeal.
That is correct, and they did neither. They let it sit for 3 years.
What was the basis for seeking the attorney's fees? Was it the lease?
Actually not. We don't really know. I think what they're looking for here is attorney's fees based on the fact that a motion for contempt was made and they were looking for their costs in opposition. But in addition to that, I think that they are adding some lard to it in that at least they're asserting that they're looking for attorney's fees going back to 2011. Now,
Just because they had to commence an action or proceeding to eject or evict the individual who was living there based on the fact that it was the mother's apartment or the father's?
right.
And they wanted to transfer the shares, and the co-op says, no, that's not how we do things, right?
correct. And
Oh, then there was no, the tenant or the occupant son was never a signatory to any proprietary lease with an attorney's fee provision that would not necessarily give them the right to seek fees, correct?
that is also correct, Your Honor. Thank you. But the key thing was that that case was resolved and disposed as per Justice St. George's order in 2019.
No, but what my colleague said is there's a point that is worth noting is that there really was no attorney fees component against your client, right? Because they weren't a signatory to a lease. I mean, you can't It's not by way of relationship. It doesn't work that way, right?
His occupancy was terminated, and therefore the.
Well, it didn't even matter because he wasn't a signatory to any agreements or anything.
That is correct.
That is part of what moots the attorney's fee.
Yes, it is. And that therefore was not a simple brush of the hand or, musing. That was a ruling.
Thank you.
Thank you.
So, counsel, what was the basis for your claim for attorney's fees?
It's against the estate, and the estate is the holder of the shares. So it's not against the individual of Eric Frankel. It's against Eric Frankel as executor of the estate of Gloria Frankel. And Gloria the estate was in fact in violation of the terms of the lease by permitting an unlawful occupant, which is what formed the basis under paragraph 15 of the lease to seek attorney's fees.
But once the court says that your attorney's fees claim is moot, in essence disposing of those claims, then what is it that you are supposed to be doing?
What we're supposed to be doing, so the counterclaims were not adjudicated by the dismissal order.
They said that they were moot.
Yes, and in Ballin versus Aero Mayflower Transit Incorporated, 144 AD 2D 407 out of the Second Department, it actually dealt with the underlying law was similar to here, in which they held that when there's a holding of mootness, it's not to the substance, and in fact, it does not require what respondent states it does in the opposition brief. Instead, it overturned the lower court's decision on the grounds that mootness is not a basis.
Was that a decision on appeal?
Yes,
So somebody appealed,
yes.
and that is not what you did.
We are appealing the lower court's order that looked back at the dismissal order that held, that in fact hinged on this concept that the dismissal order was rendered the 2013 and so ordered stipulations moot.
But that first order, that first dismissal order, did you appeal that one?
I do not believe so.
Okay.
But the last thing that I'd like to point out with the last bit of time is that, in fact, the so ordered stipulations and the ejectment order on its face did not deal with the counterclaims at all. And of course, that was the basis of the dismissal order, holding that the ejectment order and the so ordered stipulations. But under this court's most recent ruling in 2022, as it's facially not on the record, that the so ordered stipulations adjudicated those claims, which they could not have, this court can in fact look back.
All right.
Thank you, Your
Thank you,
Honor.
counsel. Thank you. Simongo versus New York State Department of Financial Services.
Good
Might
afternoon.
pull the mic down a little bit.
Thank you. Good afternoon. Antonia Casoulas for Mr. Simongo, the appellant here. We submit that the lower court erred on for a number of reasons, and reversal is warranted. First and foremost, the trial court applied an inappropriate evidentiary standard.
Yeah, I saw that in the decision. She kept, it wasn't once, but it was a repeated reference to evidence, evidence, evidence. This is what 3211 motion, right?
That's right. This
On
is a
pleadings.
pre-answer, no discovery motion. And the standard she applied seemed to suggest that she was deciding a summary judgment motion, where we've had the benefit of discovery and taking the depositions of the witnesses. Combined with that, and this is the more troubling part for me, was that the complaint does reference the fact that he was subjected to a disciplinary memo, that he was he received a suspension notice. The defendants take the position that by referencing these documents in the complaint, somehow the plaintiff, full stop, accepted them as true.
Those documents, was that particular document the one that set out the defendant's claim as to how many hours he'd missed? Was that attached to your complaint?
No.
It was
And
only
in fact, we
referenced.
didn't even reference that. We didn't.
But it was attached to their motion.
It was attached to their motion, and they're taking the position that anything that a complaint in a discrimination matter references. So if any employee said, I received a termination notice on this date, somehow they're accepting the employer's reasoning that's set forth in that memo. And I just think if the court were to accept that logic, this would upend not only, well-established, authorities on motions to dismiss, and in the state of New York, we still have notice pleading standard, but it would also, I think, impact summary judgment decisions. So that it was troubling. The defendants claim that the judge just made these things in passing, just said, oh, you have no proof of this, you have no proof of that. Well, at this stage, the plaintiff is not required to have the proof. We just make the allegations. With the benefit of discovery, maybe some of these things are going to be true, maybe they're not. Maybe, for example, my client, although not required, also alleged pretext here. He's saying, yes, they brought me up on charges, but they used the electronic record, the electronic swiping mechanism to bring me up on charges, and that's against the collective bargaining agreement. There was a pending grievance regarding that. So there were other elements in the complaint that challenged the motivation behind what the defendants were doing.
So it was error for the court to have considered the information from the city as to the 300 and some odd hours of wrongful hours logged in for payment, correct? That was hearsay.
Well,
Wasn't that part of the evidence the court used?
No, that was I think it was attached to the affirmation of one of the attorneys for the agency.
That's my point. So
Yes.
that would be, it was impermissible at this stage to consider that.
That's right, it would be. And then
And you said,
to-
I think there were 3 reasons that you were seeking reversal. I think you've told
Yes.
us 2. What's the third one?
The second one, and maybe this is an issue of first impression before this court, although I think there's decisions that touched on it, is the post-amendments to the New York State human rights law. And the New York State human rights law was amended to essentially mirror in many respects, mirror the New York City human rights law. And we submit that although some claims accrued, and I stand corrected, and I think defense counsel noted that, the date of accrual should have been from October 11th, 2019 onward, rather than, I think we were arguing the filing, but that was the law was, there was a memo that I think a bill that was introduced to change that. So we're accepting the defendant's argument that any claim accrued after October 11th, 2019 would be subject to the amendments of the New York State human rights law. And under those amendments, certainly we don't believe that the judge, although she said she considered it, didn't really consider it.
Thank you. You have reply time.
May it please the court, Assistant Solicitor General Kwame Kosa for the state respondents. Picking up on the issue of whether or not the decision below considered evidence that was in the motion, the attached to the motion is dismissed. To be clear, the Supreme Court didn't consider facts outside the complaint. The complaint itself admits that the appellant here had time and absence issues, and that was the.
They didn't admit the specific numbers that you claimed in your Exhibit F, for which you established, as I could see it, no foundation at all, except that it's a true copy of it. But I didn't see anything that established a non-hearsay basis for Exhibit F, which I believe is the source of those numbers.
That is correct, Your Honor. The only,
What was the non-hearsay basis for that?
Well, Your Honor, our argument here is not about hearsay.
Counsel, why should the court rely on that if you don't establish it's not hearsay?
Well, Your Honor, we're arguing here that the court didn't actually rely on the number of hours necessary.
You're agreeing that the court should not have relied on the number of hours?
No, we are arguing that the court may consider documents that are incorporated by reference.
If they're but that document was not incorporated. Assume for a second that I disagree with you about whether the court may consider documents which the complaint mentioned but didn't attach.
Mm-hmm.
the only source of those numbers was the document attached to your papers,
That is right.
for which you established no evidentiary foundation. Why
Correct.
should the court consider the substance of that document, given that you established no evidentiary foundation other than that it was a true copy?
Well, Your Honor, the basis for considering it is the fact that it was incorporated by reference by the appellant.
Okay, I asked you, the first sentence of my question was, assume that I disagree with you about that.
Okay.
How else do you get it in?
Well, we don't have another evidentiary basis here for getting it in here. And I
Right,
think I want to be clear, my argument
That's what I
here,
wanted an answer to.
apologies, and my argument here is that the court didn't actually necessarily rely on the number of hours the appellant missed work in 2019, because the appellant himself has alleged in his own complaint that he was absent from work significantly during that period and was being written up and subject to progressive discipline because of his absences, and even admits on paragraph 118 that he was making significant improvements on his absences as a result of the progressive discipline he had received in August of 2019. So there's nothing in the decision below that necessarily could not have come from the complaint itself. The only thing is the number of hours.
The complaint itself didn't have the actual number of hours in it, right?
That is correct, Your
That
Honor.
appeared in the decision, correct?
That is correct, Your
So
Honor.
that came from your exhibit, correct?
That
Not
is correct, Your Honor.
Okay.
And
So it's
Now-
hard,
Go ahead.
it's hard to really argue that Supreme Court did not look at the numbers when, in fact, the numbers are there. You know, you're standing there saying, no, you know, the complaint, we take in the complaint, but Supreme Court used the number to bolster its final conclusion, so they had to use it somehow.
well, the court did refer to it, but if you read the totality of the decision here, it's not the number of hours the appellant was absent for work is not necessary in order to make the determination here about whether or not the appellant here stated a claim for sex discrimination.
Counsel, what was the ultimate relief in the order?
Pardon?
What was the relief by the court below in the order?
We-
What did the court determine here?
Well, we would ask you to affirm the dismissal of the complaint here, and
But was that the relief in the order?
in the order below, yes, the order dismissed the complaint for failure to state a claim. And so we would, even if the court disagreed with the legal standard that the court applied below, this court could still consider on the de novo record whether or not the standard applied could apply the correct standard on appeal.
But do you agree that the decision below talked about the plaintiff's failure to establish certain things by substantial evidence, which is not the standard on a motion to dismiss?
Your Honor, the decision below has some references to evidence and things like that.
Would you agree that's problematic on a motion to dismiss?
It would be problematic for the court to apply the summary judgment standard, but the court did not apply that standard here.
How do you know that?
Because the court specifically said it was applying the motion to dismiss standard. It said it was construing all.
What about the 10 times it referred to the plaintiff's failure to produce evidence? We should just disregard those 10 comments by the court?
The court uses the word evidence. It's not an appropriate term, but it's not if you read the totality of the decision, it's clear that the court is considering these things.
You know, I'm hearing your arguments, but my understanding is when you do a 3211, you're pointing to the sufficiency of the allegations. And it seems like what Supreme Court did, the motion court did, was go a little bit further than evaluating whether or not checking off all the boxes to actually state a cause of action for discrimination. It just seemed that went a little bit more further than that.
Right.
You know. Okay, thank you.
My time is up.
Just like to address one issue. The court.
Actually, could you address the statute of limitations issue? The statute of limitations issue.
Yes, it's a 3-year statute of limitations.
Yes, I know it's a 3-year
Yeah.
statute of limitations, but many of the allegations in your complaint are older than 3
Right.
years. Could you address why we should consider those?
Yes, well, there's the continuing violation theory, and that's our theory on this. But there are plenty of cases, and one that I didn't cite in my main brief that I attached recently, that addresses
the
the
one you
issue
just
of
gave us?
whether the continuing violation theory is appropriate to be determined on a motion to dismiss stage. And in that case, clearly this court held no, because there's a lot of different facts that need to be developed in the record. For example, one of the arguments that defendants make is, well, different people make different decisions about this individual at different times. Well, yes, but we argue that they were reporting to the same individual all this time, and she was really directing what was going on with the defendant, you know, and this is something that would probably need to be established after discovery to see what role she had, if any. So I think it's premature for the court to really address the continuing violation issue here. And because anything that occurred after 2018, January of 2018, as timely as defendants concede, you know, we do have the more important claims, the more egregious claims, the termination, the suspension without pay, all occurred in 2020 and 2019 and are clearly timely.
Okay, thank you.
Thank you.
Kelly versus City of New York.
Good afternoon, Your Honors. I'm Cy I. Lord for Lord Law Group, PLC, on behalf of Plaintiff Appellant Angela Kelly. We respectfully request that this court rule that it was error to deny appellant's default motion, and it was error for the court to consider the motion to dismiss made pursuant to CPLR 3211A7 and 3211A5. Or, in the alternative, we request that this court rule that it was improper for the lower court to dismiss certain paragraphs of the complaint relating to...
I didn't see where the court actually dismissed any paragraphs.
Yes, Your Honor, actually...
I'm sorry, it listed a number of paragraphs, but then there's no verb. So I don't know what it was doing to those paragraphs.
Your Honor, the way it was interpreted was that these paragraphs were ultimately dismissed.
What does it mean to dismiss a paragraph? I'm not aware of anything in the CPLR that permits a judge to dismiss a paragraph.
Well, I would agree with you, Your Honor. That was our argument as well, is that this idea of having a paragraph by paragraph analysis of a complaint and making sure that each paragraph has to, on its own, be able to afford each entire element of the complaint. There's no basis for that in the CPLR. So
Was a motion to re-argue made in Supreme Court?
a motion to argue was not made, Your Honor.
It was not made.
Why do you think the Supreme Court should have granted you a default judgment against the city?
Your Honor, very clearly because the answer was due on October 25th of 2019. Now, the city made a motion to change venue, and there's nothing in the CPLR regarding an automatic tolling of proceedings when a motion to change venue is made, pursuant to CPLR 511C. So our argument is very clear that the respondent knew that they were obligated to get the tolling of the time to answer the complaint. We know they were aware of this because they had an order to show cause, which they filed in Kings County on October 24th of 2019, as well as in the instant motion that was made to change venue on October 25th of 2019. They actually argued that, requested that the court stay proceedings and allow them time to answer the complaint. So it's very clear that everyone knew at the time that the answer was due, and they decided not to answer the complaint. And in fact, the motion to dismiss was made 249 days after the answer was due on October 25th, 2019. Now, even assuming, for the sake of argument, that some of that time was precluded because of COVID-19, they were still incredibly 5 months untimely in terms of filing a motion to dismiss pursuant to CPLR 3211. So we say it was improper for the lower court to even consider the motion because the answer hadn't been filed. And
You're not appealing, I don't see in my records here, I just want to be clear, you're not appealing the denial of your motion to amend the complaint, are you?
no, I'm not, Your Honor.
Okay.
Okay. Just very briefly, Your Honor, I do want to address that some of the claims were dismissed. The claim of hostile work environment was just dismissed in its entirety.
You're really afraid, this is like a really strange situation, because what we have in front of us is an order with no direction, but essentially saying certain paragraphs are out. But your claims are still, from what I can gather, and maybe I'm wrong, your claims are still alive, right?
Well, Your Honor, it's
can't
unclear.
tell.
And respectfully, it's unclear. We would make the argument, maybe on behalf of the lower court, that our claims are still there.
Yeah, because they didn't dismiss anything. She
Yeah,
just
they
took out
dismissed
some of the
paragraphs.
facts.
But again, we would argue two things. One, we would argue that it's unclear, the lower court, in terms of interpreting, what the claims moving forward would be
Why shouldn't we
unclear.
just send it back for the court to actually rule on the city's motion that was made, which was to dismiss the complaint as opposed to dismiss some random paragraphs?
Well, I think, Your Honor, that they did rule that it was improper, that the motion to dismiss the entire complaint was denied.
No, it
And-
doesn't say that. It says the city's motion is granted in part. That's all it says.
That's it. And then it lists a
which
bunch of
part?
paragraphs. Then it listed a bunch of
Right.
paragraphs.
So why shouldn't we send it back for a consideration of the motion on its merits, which apparently haven't, as far as I can tell, weren't decided?
We don't know what you have left, basically. That's on my mind. I don't know what you have left after.
Well, one reason we're here, Your Honor, is because it is kind of unclear, and we wanted some type of clarity moving forward in the case.
Usually that's done by a motion to
We
re-argue.
argue.
Well, Your Honor, what happened was
That's a good use of a motion to re-argue. I mean, judges make mistakes. They leave out verbs, they leave out words. Sometimes motions to re-argue are a good thing.
No, I understand, Your Honor, and sometimes motions we argue are definitely appropriate. I think in this case, part of the reason we decided to go this route is just because we do believe that the initial motion was untimely, and there's been no substantive analysis or critique of the timeliness of the motion, and again, I want to be just clear that the COVID-19 only accounts for maybe a month or two of the delay, and that there was 5 months total in terms of when they filed their late motion to dismiss.
Thank you.
Thank you, Your Honor.
Forest and trees.
That's what happened.
May it please the court, Hannah Sorokin for respondents. I'd like to start initially with the motion for default that was providently denied.
Can we start with why you didn't move to re-argue? I mean, the court said your motion was granted in part and then said nothing else. It seems to me the right remedy at that point is to go back to the court and say, help us out here. Did you leave out a few words? Why didn't anyone do that? Counsel explained why he didn't do it, because he's going on timeliness. But why didn't you do it?
Well, Your Honor, our reading is that it is clear what was dismissed and what was allowed to proceed.
I'm reading, the decretal paragraph says, the city's motion is granted in part.
And then
That
lists.
doesn't say what part.
And then lists a bunch of
And then
paragraphs.
it lists a bunch of paragraphs. How is that clear?
So on our reading, what survived the motion to dismiss were appellant's allegations about their request to adjust their work
So you want us
hours.
to read parts of the decision into the decretal paragraphs?
I'm sorry.
Are you suggesting that we read parts of the opinion part of the decision into the decretal paragraphs?
Well, part of the reason that the Supreme Court addressed paragraphs the way it did is because so many of the allegations were clearly precluded, and so appellant essentially.
But what gives her the authority to preclude? First of all, she doesn't ever say precluded, but what would give her the authority to preclude paragraphs? What in the CPLR allows that?
So the paragraph or the allegations that were precluded were the allegations that
I'm asking you about the CPLR. What in the CPLR permits a motion court to preclude certain paragraphs at the motion to dismiss stage, factual paragraphs?
I don't have a reference to the CPLR.
It's only scandalous or prejudicial, and you didn't ask for striking allegations as scandalous or prejudicial. You're asking for dismiss the complaint, which I have asked you a question. Why wasn't there a cross appeal here from you folks saying, you know what, the court should have just dismissed the whole complaint? Because if you just assume arguendo that the court in the decreto meant to strike these paragraphs, there was nothing left of the claim, so the whole complaint should have been dismissed. And I'm just curious, why didn't you even take a cross appeal? You just were left with a lot of question marks as to what is remaining.
From our read, Your Honor, it is clear what was left. There were allegations related to the appellant's request for adjusted work.
All those allegations that remain don't support the cause of action, right? You would argue that? I mean, if you would just If you would just take a pen and cross out all the allegations that the Supreme Court says should go, assuming that's exactly what Supreme Court meant, and what you were left with, and I did this, doesn't really add up to much, right? There's nothing to prove for the plaintiff because there's nothing left because struck them out.
Well, on our read, what is left is a claim about a purported
What's
denial
left is a
of-
label, the claim, and some other kind of paragraphs, but that's it.
Well, under the discrimination claim, what survived was the purported denial of their reasonable request for adjusted work hours, and then under retaliation.
Yeah, but that's it. That's all that's left. But there's nothing else to it. There is no further allegation of, you know, why that refusal of the accommodation, what amounted to that refusal of accommodation amounted to a discrimination. That's gone. She took it out, or at least we think she took it out.
We would agree that the merits of the claims are certain allegations that had been already adjudicated before the State Human Rights Division, before the administrative law judge that recommended Kelly's termination, that those allegations were precluded because they'd already been adjudicated, and the law here is clear that you can raise claims either in an administrative proceeding or in state court in regards to this.
Did you ask it anywhere in your motion that those paragraphs be precluded at this stage?
We did argue preclusion and collateral. We argued election of remedies, preclusion, and collateral.
Did you specifically ask that factual paragraphs be precluded?
Our reading is that the Supreme Court did
No,
that.
I asked you a question about what you were asking for. Did you ask that certain factual paragraphs be precluded?
I believe, I was not the trial attorney, but I believe we
Counsel, I assume
requested,
you're familiar with the case.
of course.
Did you ask that certain factual, for the third time, did you ask that certain factual paragraphs be precluded?
Not by paragraphs, but by allegations and what had been previously adjudicated.
Thank you.
I will be very brief, Your Honor. I just wanted to say that there was one claim also that was whether discriminatory animus, there was discriminatory animus towards appellant when it came to a determination. And respondent argued that that was actually decided in the lower court, an administrative law judge. And we want to make clear that there's nothing, the administrative law judge at no time addressed or was presented with any arguments regarding discrimination towards her disability.
I mean, would you disagree that by striking these paragraphs that we think are struck, there's nothing left for your claim, right? Your claim is missing certain elements.
I would respectfully disagree that there's nothing left, Your Honor, but I would say that it does. Well, a lot of when you do a paragraph by paragraph, you kind of start a thought and you can't finish the thought.
Yeah, that's okay.
And so what's
becomes
happening is that I'm describing a claim, but the second half of it I can't mention, and it becomes very hard to litigate because you almost have a gag order in effect for the inability to talk about freely about what happened.
Well, in a sense, the court cut off your sufficiency ability. I mean, you can't argue sufficiency. I plead a sufficiency, but you took the paragraphs out, so I can't do it anymore.
Yes, Your Honor, and and again, the motion that was made for the entire complaint. It wasn't made for a paragraph by paragraph for certain claims. They made the argument the entire complaint in its entirety should be dismissed, and I think that was error in the court's part to consider that. So, Your Honor, we thank you. If there are no further questions,
Thank you. Stagen versus New.
Okay. Good afternoon, members of the panel. My name is Peter M. Levine, counsel for the appellant Thomas Stagen. In their settlement agreement, Amy New and Richard New devoted 2 full paragraphs encompassing 216 words to Thomas Stagen's current and future relationship with Edenwood Realty LLC.
So essentially, those 2 paragraphs support your claim that Mr. Stagen was a third-party beneficiary.
Precisely. Why include him in the settlement agreement? If you do not want to have, you don't want to benefit him, do nothing, say nothing. He was an employee at will. He was serving at the pleasure of Richard New. Richard New could have fired him at any time.
And that his payment to him through Phyllis Consulting as a tax procedure actually took place before the settlement agreement, correct?
That is correct.
And it took place during the settlement agreement, and it took place after the settlement agreement, correct?
Precisely.
In which your friend's client actually paid checks acknowledging his services to Edenwood.
And more than that, he was explicitly appointed. Look at page 250 of the record. There was a resolution signed by Richard New appointing Thomas Stagen as the president. So if we look at paragraph 6, which uses the phrase continue to employ twice, let's look at it the first time. Amy and Richard agree that until Richard retires or dies, Richard alone would decide whether the company would, quote, continue to employ Stagen. Now, what will continue? Stagen's relationship with Edenwood as it existed at the time of the settlement agreement. It is not possible to continue something that doesn't exist.
They argue that at the time that this was entered into, he was in reality not an employee.
I disagree.
The relationship was with Phyllis Consulting as opposed
No, the relationship was with Thomas Stagen. What did they want to accomplish? They wanted a benefit. They wanted a benefit for themselves and a benefit to Stagen.
Well, you know,
How
the thing.
Stagen is paid doesn't benefit them one way or the other. What they wanted was his continued services. He had been running this company for 5 years very successfully. That was the benefit they wish to incur. They get no benefit.
Did it matter if they paid him a salary or not?
Does it matter? No, not at all. Because also the word employ, which we define in our brief, encompasses the precise relationship that Stagen had through Phyllis Corey with Edenwood, which is to appoint as an agent to run your affairs. And that's exactly what had happened here. He was appointed by written resolution to run Edenwood as president. If you look at the second use of the phrase continue to employ, let's take a look. Assuming that as of that time, the retirement of death of Richard, Stagen remains, that's a critical word, remains employed by Edenwood, Edenwood shall continue to employ Stagen. Now, what could remain? What was already there? What had been in existence prior to
Counsel, let me
Richard's
ask you this
retirement?
question. The defendant here didn't know about this arrangement that that your client had with the father, did she? I mean,
We don't allege that she knew.
okay.
We don't allege that. But what did she know? She knew he was running the company. In fact, he had replaced her. She had been fired.
So do you? So the way I look at it, and I thought it was when Supreme Court said it would have been clearer and cleaner to acknowledge somewhere that he was actually referring to the plaintiff and his company. That's not really. It's pretty straightforward. You're saying, look, this agreement, these provisions is very clear on its face. If my guy's working and is employed, it doesn't matter what capacity. It's as we're tied to this company. So you got to do the good faith analysis of whether or not I'm still performing my employment duties before you can get rid of me, right? I mean, that's it. That's essentially it, right?
Well, right.
It's not a hard question. It's
Right.
Okay. You got it, right?
No, I'm going to knock that softball question out of the park. I agree with you, Your Honor. You are precisely right. And the phrase shall continue. What will continue? Stagen's relationship with Edenwood, and what was that relationship? What it had been for 5 years preceding the settlement agreement. Stagen is president and daily manager of Edenwood. The benefit they were going to get from that relationship was his continued service as president of a company he had been successfully managing for 5 years.
That didn't, that was not in perpetuity. There were conditions that had to be met.
Precisely. Until Richard retired or died, it was within his sole discretion whether Edenwood would continue to employ Stagen. Once he retired, Amy would become president, but then she had to make a good faith determination that he was no longer capable of performing his duties competently. She made no such determination and made no attempt to make such a determination, and therefore breached the settlement agreement of which he was a third-party beneficiary.
So just one final point. Sure. I know the time is up here. So when she communicated to your client that he was being terminated, she didn't say in that communication that it was because he was incompetent. Correct. In the language of the agreement. She said she had communication problems, whatever that means. So your client had no idea why he was terminated at that.
Precisely. It was utterly arbitrary and not at all in compliance with.
And this whole notion of incompetence was really born after this litigation.
Precisely.
Thank you. All right, you have rebuttal time.
Sounds as though I have my work cut out for me here. Judd Burstein for the respondent. I think that this whole discussion.
So let me ask you a question. I'll get right to the heart of it. You got this provision in here that says that he can be terminated, the plaintiff can be terminated after your client makes a good faith determination that the plaintiff is no longer capable of performing his employment duties competently, right? Yeah, I can't help but think that she fired him by saying that your consulting agreement has been terminated. Is that a way to get around the good faith requirement under this agreement?
No, I don't think
like
so.
it.
And I think where it starts is, of course, the plain language.
Right.
Employ means employ means employ. It's whether or not you look at it from the dictionary definitions. If you look at it even from the labor law, he would not be an employee under the labor law.
Don't you also have to look at it in terms of what his relationship to the company was at the time the stipulation was signed? Because if the stipulation refers to his, to Mr. Sagan's relationship with the company at the time of the stipulation as employment, then isn't that the definition that governs?
Respectfully, no.
I mean, well, let me ask you.
Yeah, I do follow your question.
I mean, do you agree with me that at the time the stipulation was entered into, he was working at the company as the president of the company and was being paid by means of his LLC, whatever. So why isn't that the employment relationship that has to continue?
Well, one of the issues I would say is that if it's a third-party beneficiary, there has to be mutual consent. My client, they concede, did not know that this was a consulting arrangement. How
did that change it? She was agreeing to the idea of his being the employed. Why is the nature of the payment of importance to her if she knew that he was doing his job well?
Well, it's not. First of all, it's not. It's a plain language argument. That's what the agreement says. But beyond that, you don't respectfully treat the corporate form as a smorgasbord. You get the benefit in one circumstances, and then you turn around and you say, "Well, no, I'm really the same." For example, in the usury context,
That goes to the plaintiff's, problems that he's going to have to deal with the taxing authorities and with other authorities. But in terms of what he's doing here, as my colleague pointedly points out, that going into the stipulation, regardless of whether or not your client knew of the relationship or not, when the father and her wrote this stipulation or agreement, he was already a consultant. He was already being employed as a consultant. So that, as my colleague points out, that's the relationship. Even though they use the terms employed or whatever, the course of conduct going into that stipulation was a consulting arrangement. And then, like I go back to what I said earlier, she figures it out and say, you know what, I'm going to terminate the consulting agreement so that I don't have to go through the good faith argument, which can be fleshed out at the APT, not at the pre-answer stage.
Of course, I understand your
There's a
point.
lot in there.
And
I told everybody, we do read the record.
You sure do. But I would say you also have to address respectfully the damages issue. Although he says in his complaint, I was paid a salary, which is just not true. He wasn't paid a salary. His company was paid a salary. If there are damages here, who's the damaged party? It's not Mr. Stegan. This is exactly the point about the corporate form. This is what the trial court said, or lower court said, regardless of the other arguments, how can he show damages where the relationship was with a different entity? How do you even assess damages? Because the question is not what his entity pays, what his entity receives, it would be what he receives. That is a fundamental problem. Who is the injured party in this case?
Wasn't it sort of like a pass-through that all the assets of the corporation were in reality Mr. Stegan's, that the only thing the corporation had was what he was paid?
Not what Mr. Stegan's affidavit said. And if you give me 2 seconds, what he said, he chose to do it, even though I would be taxed at the corporate level and I would be taxed individually. He said it's a C Corp. That's not me, and if you give me 2 seconds, I'll find it. It's in his affidavit.
We'll look at, don't eat up your time. By looking
Okay,
for something.
I think it's my, no, I guess my time's up. But
Thank you.
I would ask you to see it by his own agreement. It's a C Corp, but even if it weren't, you still don't get the benefit of all of
All
the
right,
protection.
we'll take a look at it. Thank you.
Damages is an issue of fact. Stegan's the sole shareholder of Phyllis Corey. We point out in the reply brief that a sole shareholder is the equitable.
You know, at bottom, he got terminated. He was supposed to get paid. There's your damages, right? I'm losing out whatever income that, unless you can show good faith, that you've done a good faith analysis, I'm out money.
Right.
How much? We'll figure that out.
Exactly. Again, whatever existed at the time of the settlement agreement is what Richard and Amy wanted to continue.
Well, so much of Richard. I mean, Amy conceivably didn't know about the arrangement,
Well, maybe
right?
she was going to come in and try to.
Well, it doesn't matter, right, what she knows or no, but it still bothers me that, you know, this may be an end run to, like,
Yes, that's
somehow figure it out.
That's precisely what it was.
Maybe, I don't know, who knows?
But bottom line,
It's
they
clear that
intended.
what she did want was to continue to have him as president.
Exactly. How he was, they did not care when they signed this settlement agreement about how he was paid. They wanted him to continue because he knew what he was doing. He knew this company. Amy was coming in cold after 5 years. Richard wanted to be sure that there'd be continuity, that she wouldn't come in cold, not know what she was doing, and run it into the ground. He wanted Tom Stegan there to protect his interest, and that is precisely why he was in that settlement agreement. Edenwood gets no benefit. Amy and Richard get no benefit if Stegan draws a salary directly as opposed to taking it through Phyllis Corey. It's utterly form over substance. They wanted him there for his managerial expertise. They were a little clumsy in how they wrote that protection in, but they wrote it in. He's a third-party beneficiary, and the court, the IAS court, disregarded the resolution appointing Stegan as president of Edenwood, overlooked the critical words remains and continue in paragraph 6 of the settlement agreement, and misconstrued the word assuming to impose a condition preceding.
Okay.
Assuming is hypothetical. It is not conditional.
Thank you. Got it. Thank you. Casaforte Limited versus Portavusi.
Good afternoon, Your Honors. May it please the Court, my name is Jeffrey Metz. I represent the appellant, Your Honors, I'm here this afternoon asking you to modify the decision to dismiss the ninth cause of action, the sole cause of action that is asserted against my client. What
Would
we
it be because they kept the proceeds?
Well, they certainly did, Judge. I mean, they sort of want to have it both ways. They
They got the mortgage paid off. It was paid off, right?
the initial debt was all paid off, and their beef is not with us. Their beef is with
No,
Johnson.
the beef is with you because you prepaid the mortgage and they lost out on the interest payment.
Well,
That's the beef.
there's no basis to keep this claim alive.
So in other words, the equitable estoppel argument is
The
what's at play
the
here.
estoppel argument is clearly my strongest argument here. You cannot take the mortgage, you cannot ratify it, and then turn around and say that there was no authority to enter into it in the first instance.
It's better than ratification. They took the money.
Yes, they did. They
It's
took
better
the
than
money,
ratifying.
And you know, the thing here is that my adversary would have you believe that there was some sort of distinction between Johnson and the entities, because it's the entities that are on the CMAs, and it is the entities that are on the HUD statements showing that they took the money. Now, also, in addition to all the foregoing, the complaint really does not state a cause of action against us because it's all predicated upon information and belief. I mean, I think that Casaforte is trying to be a little too cute by half here. You know, you have the XYZ entities, they're plaintiffs and defendants in the same case. They were brought in.
Yeah, I had to have a flow chart for myself to keep track of the XYZ guys. They were plaintiffs, they were defendants, you know, geez, I don't know.
It's a little confusing, but I can tell you the bottom line here is they want to get back the $1.6 million that they say, that they allege, and they can't even prove at this juncture, that Johnson took. Their beef is with Johnson and the law firm and the chief of the law firm there.
But
That's what the cause is. Those
Do
are
they
the-
have an action against Johnson and
Yes,
law
Your
firm,
Honor.
the attorneys?
Yes, Your Honor. There's a consolidated action where there are multiple causes of action, each seeking, well, it says in an amount to be determined by the court, but we know if you add them up, it's clearly more than the $1.6 million.
But the bottom line here is that the ninth cause of action, where they're seeking a DJ action to declare null and void this mortgage, from your point of view, has to be dismissed because they kept the money.
Because they kept the money, because we didn't have an independent duty to verify the authority of Johnson to enter into this after all the documentation that he gave us. Thank you, Your Honor. Thank you.
Good afternoon, Your Honors. Lauren Gershuni from Genova Burns for plaintiffs, respondents. In their appeal, lender defendants almost entirely ignored Judge Chan's opinion in their
Well, let me just, the question is, did the debt get retired? It's either yes or no, right? Did your client's debt, did your client, what was owed to your client, was it satisfied?
So it's not been established whether the fee owners did in fact receive any of the proceeds of the
How can you not
refinances.
establish? It's your client. You either can say, yeah, we got it, or we didn't get it. You can't just stand there and say it hasn't been established.
The fee owners believe some, if not all, of the proceeds were misappropriated by Johnson and his then counsel, Porta Vusi.
The entire $5.8 million?
I'm not sure how much.
But don't the HUD statements show where the money went?
Your Honors, as a procedural matter, I'm sorry about this, but this argument was scheduled even though lead counsel could not be here. So I'm at a disadvantage because I do not know all of the.
Oh, I'm gonna let Justice Gesman respond to that.
I'm not gonna say anything.
That's like, that stuff. I mean, you're here, so we gotta go.
I am here, but I can't answer, what amount, but there is a belief that not all of the proceeds went to our clients.
Well, that could be, but the bottom line here is they have an equitable estoppel argument. That means, based on well-settled case law, if you didn't give back any of the money that you felt didn't belong to you or shouldn't have been given in your direction, You can't claim the mortgage was null and void. That's what you're seeking in the ninth cause of action. That they were, share state wrongly knew or should have known that Johnson wasn't authorized to sign off and accept the mortgages without Casa Force permission. I mean, that's the essence of what's going on here. That's what you're seeking. And they're saying, well, you kept the money. Whether it went, we know it went to the HUD because you have statements verifying that the mortgage was retired. So now we're left with a little bit that Casa Force would, I guess, would like to keep, and it went to Johnson, and that's between them. But why is that share state's fault?
So there are,
You following? And
Yes.
that's the essence here. So what's your position on that?
I think at this stage, at the pleading stage, there are questions of fact as to the equitable estoppel and unclean hands issues.
Okay, thank you.
I'll rest, Your Honor.
Okay, thank you. Thank you both. Lee versus 33 Captain Claus. That's a really good name, Captain Claus.
Yeah, it's great.
Hey, counsel.
Yeah, if it please the court, Robert Basil for the appellant Lee. The parties agree that the dispositive issue on this appeal and in the case is whether my client is a shareholder, continues to be a shareholder after an agreement was reached.
Well, so look, he was asked, your client was asked, okay, we have this looming large debt. Okay, and you're going to be personally responsible for it, there are three shareholders, each of you, all three of us could be personally responsible. I'll take it over. The defendant says, I'll take over if you just sign over the shares to me, right? I mean, essentially, I'm letting you off the hook.
Okay.
And there are a couple of problems, right? One of them is that according to the agreement, you need to have everybody sign. You need to have the other shareholder sign also, because there was also a situation where the other shareholder may not want one shareholder to get your shares, right?
Correct.
And that didn't happen here.
Did not happen.
Right, and then there's also the $1.6 million COVID relief money that somehow came about after the fact, right? That's a little problematic, because I couldn't understand why would there be a complaint here, or there's a law action here, if you're going to be relieved of all the debts, and then, oh, lo and behold, there's a $1.6 million pot somewhere.
Right.
So that's a problem too, right?
Correct. And of course, the main problem that we put out in the paper.
Well, those weren't main problems, but okay.
Yeah, those are minor problems, Your Honor. The main problem was that there was no consideration for the exchange. It was a misunderstanding created by the assignee that my client was responsible somehow for 1/3 of the company's debt. It's not true.
At the time that they entered into this assignment,
Yes.
what was the amount of the debt?
$250,000 thereabouts.
$250,000. Was your client able to determine the fair market value of his shares at the time of the assignment?
No.
If there was an assignment, was it for fair market? Should it have been for fair market value, or for some nominal value?
No, it should have been under the shareholder agreement for fair market value.
How was your client to determine the fair market value of the shares?
Well, there are methods that weren't used.
Like?
Usually you get an appraisal or some CPA to go through the books and records.
Was any of that done? Was any information provided to your client so that he could determine the fair market value of his shares at the time of the assignment?
No.
At the end of the day, if we divide the debt, as you stated, into three, your client would be responsible for 1/3. Would his shares at that time be worth what supposedly was his share of the debt.
Well, I don't understand how the debt gets divided in thirds. The shareholders' agreement does not provide for individual liability, but if somehow we were going to say that he was responsible for a third, then we would have to look at the past revenue of the company, project it into the future, subtract the debt, look at the possibility of government, intervention.
So your client doesn't mention the transfer of these shares in the pleadings, does he?
I'm sorry, what was that?
Does your client include information with regards to the transfer of the shares in the pleadings?
The only information he got was from corporate counsel.
What do you mean he got? Wasn't he a party to it? Or you're saying that the transfer of shares didn't happen?
Well, the transfer of shares, the document was signed. It was an agreement that my client would be relieved of whatever his obligations were for the debts of the company in return for assigning his shares, signature on the line, to one of the other shareholders. That all happened. And it's my contention that the shareholder assignment is invalid on various reasons, which we've already discussed.
All right, thank you.
Thank you.
May it please the court, Richard Capola from Cullen and Dykman on behalf of the respondent. Your Honor, Supreme Court correctly held that in November of 2020, appellant assigned his shares of stock to respondent Captain Claus to Jean-Hoon Lee, and as a result is not
Counsel,
entitled.
but the agreement calls for the signature of the other shareholder. How do you satisfy that condition?
Section 4.3, Your Honor, of the shareholders agreement was intended to prevent one of the original shareholders from selling his shares to a third party without the consent of the other
Where does
shareholder.
it say that?
It does not say that, Your Honor, but
So
if you read,
aren't we bound by the plain language of it, which it seems to me is pretty clear that you need consent?
Right, because the plain language says under no circumstances, and then it proceeds.
we are, Your Honors. But
Well,
Section 4.
you can agree with us that there was no third signature, right? There was two. There was the plaintiff and then the defendant, your client, but there was no third.
There was no third signature on the particular assignment that Mr. Lee, that DK Lee, the appellant signed. However,
Would you also agree, as my colleague pointed out, that that assignment was not for fair market value? It was, the language that you used in papers is for consideration, but it was not fair market value. Would you agree with that?
fair market value at the time that this assignment was signed could not be determined. The fair market value.
Well, then how could it be a valid assignment?
My client swore an affidavit, and the record below, that the fair market value at the time of the assignment was zero. This was a struggling business.
Who determined that it was zero?
Unfortunately, Your Honor, there was no appraisal that was conducted. Our client put a lot of money into this business after the assignment was signed by the appellant. And in the spring of 2021, the SBA started the Restaurant Revitalization Fund to provide direct funds to restaurants. Those funds could only be used for specified purposes. So, Justice Owen, you're correct that on May 24th, 2021, Captain Claus did receive approximately $1.5 million from the Restaurant Revitalization Program. Prior to that, my client spent money out of his own pocket.
I don't think we have a disagreement, or at least I don't have a disagreement with how much expenditures, how much capital your client put in. Where we're at here is whether or not there was a valid assignment of the shares. And what I can see from this record is that you've already got, there's two deficiencies. One, you don't have the signature of the other shareholder. That's a big one. And the second is that, look, you asked for, the consideration here was the debt. I mean, somehow, somewhere, I'm reading through the record, and the sense I got was that the other two shareholders were scared out of the bejesus because they didn't want to pay any part of that $250,000 debt. They didn't have 2 pennies to rub together, and they didn't, like, we're going to be on the hook for that. So however valid that thinking was, that's the consideration to sign this. But at the end of the day, as of us look at, it says fair market value. It doesn't say consideration. So
If I may briefly address your first
Yeah.
point, Your Honor, sure. The plan was for, as stated in the record, the plan is for all three shareholders to meet in person. An appellant and Mr. Park would sign their respective assignments. The appellant admits in the record that Young-Hoon Lee called appellant and told him that Park would meet Yu Mi-hung, the corporate attorney, at a later time because Park's work schedule didn't allow him to also appear at the same time that Lee signed his assignment. Appellant,
If you're arguing that that's an exception to paragraph 4.3, I'm having trouble finding that in the plain language of 4.3, which says, under no circumstances are the shares of stock to be sold or negotiated unless consented in writing by the other shareholders. And the fact that they scheduled a meeting and someone didn't show up doesn't excuse you from the requirement of paragraph 4.3. What's your theory about why you're excused from that?
appellant admitted that he was okay, in the record, appellant admitted he was okay with signing the assignment without the
In what
presence.
form did he say that he was okay with that?
Where did he say? He stated in the record on page 42 and page 129 of the record. It was part of our statement of material fact.
But saying that the appellant was okay with that, do you have an affidavit from the other shareholder saying, yeah, I'm okay with that too? Because that's the real key, because the other shareholder could say, I wasn't okay for that. He doesn't have authority to speak on my behalf to say it's okay.
Your Honor, Mr. Park, who was the third shareholder, was okay with that.
You have that in the record? That's somewhere?
That is a part of the record.
What page?
It should be in Mr. Park's affidavit. Just to clarify, Your Honor, your question was whether Mr. Park, the third shareholder, was okay with it?
Yeah. That's important because, it's not so much what Lee is saying if he's okay with it, it's Mr. Park, because he's the one that's holding up the deal, right? If he doesn't sign, the deal doesn't go through.
Well, there was in Mr. Park's affidavit, and I apologize, Your Honor, I'm having trouble finding it. He was okay with giving up his shares.
That's very different, but that's different when saying, okay, that I agree, I don't have to sign it, let's go through with it. That's very different than waiving 4.3 requirement. Okay, we'll look for it, don't worry, thank you.
Thank you, Your Honors.
And Your Honor, just to put it in context, this was a summary judgment motion without any discovery. Discovery had been served. There were extensions given to counsel so that he could serve answers. And then all of a sudden I get a summary judgment motion instead of the answers. So I think it's very appropriate to send this back to the court for discovery so that these issues, the intent of the parties, why things weren't signed, can be fleshed out, if you will, in normal discovery. Thank you.
Okay, thank you. People, that's a submit. My mistake. Okay, we have Moses Ortiz versus FDB Acquisition. And that would be, the appellant here is RNC Industries, and the respondent here is the RA Consultants.
Yes, Your Honor.
The other case is submitted. Thank you.
May it please the court. Brendan Fitzpatrick, counsel for the appellant, RNC Industries. Your Honors, much like a couple of the cases that this court has heard before this, this case arises from pre-answer motion to dismiss. If you read RA's brief, it seems like it's an appeal from a summary judgment motion. But that's not what we have here. We have a case where RA made a motion after RNC filed a second third-party complaint based upon three essential 3211 subsections: A1, A5, and A7. There's really no debate about A5, which is the sufficiency of the pleadings. That's not really addressed on the appeal, and I submit, based upon the
The collateral estoppel,
Yes.
law of the case analysis that flowed from the first decision. I mean, you got so many.
Yes,
You have so 4, I lost count. Was there 4 third-party complaints?
I think there are 3. No, 4. 4.
4.
Yes, 4.
I didn't lose count.
Yes. No, you didn't.
All right, so everything was flowing from the decision of the second third-party complaint. I don't know what happened with the second third-party complaint.
Right. I'm the third-party complaint.
Oh, okay.
But the first one, which was FDB and Pavlak against
Right.
RA. So they made a pre-answer motion to dismiss that.
And the
based
court
upon-
dismissed it, saying,
it.
you know, you didn't, the documentary evidence showed that RA didn't have supervisory control, wasn't involved, merely an architect, out, done.
That's what
And
the whole.
everything flowing after that was collateral estoppel, res judicata, law of the case, right? That's where the.
That's one of the arguments, yes, Your Honor. So the first order does not have the preclusive effect that RA wants, simply because of the fact that it was not a decision on the merits. And this isn't a case where RA was a contractor and there was a trip and fall at the corner of Elm and Maple. And they submitted a contract that said, no, we were sued, but we did our work at the corner of Main Street and Maple.
Sir.
In our contract, I'm sorry, Your Honor.
I'm sorry. We understand that RA's major defense is they weren't involved in the means and methods, that it's all RNC.
Yes.
I understand that.
Okay.
So the essence of trying to save the fourth amended complaint, to save it, is that you supplemented with expert affidavits, making it clear that RA played a very vital role, at least contractually, had to play a vital role in being on the ground, inspecting, and doing all that stuff, correct?
Precisely, Your Honor.
Which should warrant reversal and saving the complaint.
Yes, Your Honor. I believe so. And seeing that you've basically just summarized my entire argument, I would just add one thing.
You're the third-party complaint.
Yes, I'm the third-party.
I'm sorry.
Yes.
There is a fourth one, I'm sure. But in
Oh, yeah,
addition,
there's a fourth one.
in addition to the expert and witness affidavits, there were subsequent documents that were submitted, including the actual SOE, which was the specific drawings and plans that RA prepared, and that once they were accepted, they had to be on site.
You know, the second and third-party complaint that got dismissed, you weren't really even part of that, right? I mean, you hadn't even asserted any counterclaims as
No,
to this,
we
right?
hadn't.
It was only after the decision came down that you asserted your third-party
Yes,
complaint, or you
precisely.
commenced your third-party complaint. So how was anything that happened in the second, third-party complaint can even be ascribed to you, because you weren't even involved yet?
I agree, Your Honor. To be honest, to be forthcoming, RNC did submit papers in opposition to that motion, but the argument was essentially the pleadings are sufficient.
But the way my understanding of how collateral estoppel works is that you can use it against RA if there's a negative, adverse finding if you're not a party, that is. If you weren't a party to that, and then later on something happens, you as the non-party to that prior proceeding could use that against RA if there was an adverse finding, because it had the ability, the opportunity to litigate fully everything.
Yes.
But not the reverse.
I don't believe in this case, Your Honor. It's the reverse. It could be used in the reverse.
It could.
Could not.
Could not be
Could
used.
not.
I'm
I'm sorry.
like,
In other words, maybe I'm wrong, forgive me. Collateral estoppel really is implicated in a separate, discrete, new action, right? This is really law of the case, because isn't third-party practice part of the same action?
It is. And
So then it would really be law of the case.
I think so, Your Honor.
And your position would be, I'm not bound by law of the case because I wasn't a player, as my colleague pointed out.
I agree.
Right?
Yes, it was, one, there was no decision on the merits, it wasn't a full and fair opportunity, and really, again, with the subsequent evidence, that really undermined any demand for a pre-answered motion to dismiss. That was really essentially a summary judgment motion. Thank you.
Thank you.
Excuse me. Good afternoon, Stephen Willig of Donovan Hayden for the second, third, and fourth third-party defendant, RA Consultants.
You're in all of them.
It took me a long time to get to that point, Your Honors. I think Your Honor hit the point in terms of law of the case. RNC opposed the motion to dismiss the second, third-party complaint. The same arguments it made in opposing
You know,
that
when
motion.
you say they opposed they opposed the motion to dismiss the second, third-party complaint, were they in the case at that moment?
Absolutely. They were the first third-party defendant. So they're absolutely in the case. They absolutely had an interest in opposing. They did oppose it. As I set forth in my brief, they made very much the same arguments in opposing that motion as they did to the motion to dismiss the third-party complaint.
But that's all 3211, right? That was at the pre-answer
yes.
stage, right?
Absolutely.
So
Your Honor.
anything that's tossed at the pre-answer stage, if something comes up later on, you can replead, right?
But nothing came up, Your Honor. My adversary mentions the SOE documents. They were submitted on the first motion.
How about this affidavit from the new guy, Spivey or whatever his name is?
It was not submitted, Your Honor, but as Justice Lebedev found, he was looking at the very same documents that had been submitted on the first go-around on the motions. There was no new information there. He was just looking at it and giving it his own perspective.
Was that motion denied with prejudice?
The motion was granted.
Granted, was the complaint dismissed with prejudice?
The order did not say with prejudice. I said in my notice of motion to dismiss with prejudice. The motion was quote-unquote granted.
And that was it?
But, Your Honor, if we're going to put any teeth at all in a 3211 motion to dismiss, I think we have to enforce its application going forward. Otherwise, we have litigants coming back years and years later saying, I found a new document, let me try this one more time.
But the statute had not expired, therefore, they could theoretically come up with a new set of pleadings that would have sufficed.
Perhaps, Your Honor. My position, Your Honor, is that Justice Lebedev in the first...
Leibowitz, not Lebedev.
I'm sorry. I apologize. In the first go-around, said specifically, on these facts, based on this documentary evidence, there is no claim for indemnity or contribution against RA Consultants. And we think that is law of the case and needs to be applied to all these subsequent pleadings.
But, I'm sorry. So you view that November 2020 decision, am I correct?
Yes.
As a decision on the merits? It can't be, because he dismissed it before the evidence was in. I mean, what's...
Yeah, absolutely. I think it's... I don't want to call it...
So if it's not on the merits, then it can't be law of the case binding on RA, even if they put in opposition.
But it was based
which would mean that now at this stage, given how they're supplementing the pleading with an expert affidavit, which we're allowed to do on case law, that it should survive.
But it's not so much of a supplementing of the pleading. It's just the pleading remains the same. The allegations remain the same. They're just saying these documents, we're interpreting the documents that allegedly supported a different way. We don't think that's
Well, the Supreme Court didn't, I mean, the Supreme Court essentially relied on the prior decision saying, that's it, you know, you're done. I'm not going to revisit this. I mean, that's essentially what came down to, without looking at, you know, the Justin, I forget his last names, you know.
Ivy.
Thank you. The affidavit, I mean, it was a pointed affidavit that wasn't available. I mean, it wasn't there on your...
No question, Your Honor.
Right, it wasn't there. I mean, you gave them a roadmap as to what they needed to do. So, okay, they went and got it.
Well, if anyone was aggrieved by that first decision, they could have just appealed it, and no one did. So we think that finding by the justice saying that there is no indemnity or contribution claim against RA Consultants under these facts is binding.
Okay, thank you.
Thank you.
Your Honor, honestly, I'll rest on my brief unless the court has any questions.
Thank you.
I would ask the court to reverse. I thank you for your time.
The fifth third-party complaint that's coming around the corner that we should know about? Thank you. Have a good day.
Thank you.
Thank you. We won't forget the fourth one, trust me. M-Base Corp. versus 111 West 57th Street.
Good afternoon, Your Honors. Would you like to wait for Justice Gesmer?
No, we can go proceed. It's fine.
Okay. Craig Flanders, may it please the court. I understand that there have been prior appeals and
Yeah, that's an understatement.
Right.
And I think
this is
everybody,
the fourth, yes.
except for me again, was on that bench, was on that, or touched this case.
Right, or the
That's why
related matter.
that's not a reason why Justice excused herself.
Right, and part of the reasons why there's been so many iterations is there was actually mid-litigation activity that gave on the project.
You took it to removal to the federal court. Is that the mid-level activity?
No, it's not. No, there was a strict foreclosure by the defendants that led to a total wipeout of the equity, in which is the subject of the claims on appeal here. So that act did not happen when this case started, and that's one of the reasons there's been sort of a twisted procedural posture here. The parties here, and as ruled in prior appeals, made a deal. They were sophisticated parties. And the manager said that he wanted his duties waived, his fiduciary duties waived, as this court has found previously 8.5 did. But in exchange, they replaced that with contractual duties, very specific contractual duties. And what we have done is say that those contractual duties must have meaning. And that really permeates everything in this appeal. That permeates the 2.8 obligation, which I call a know your partner rule, that we had the right to know who we were in business with and what the stakes of the other partners were. And we wanted to ensure that the manager was making decisions with a personal interest at stake. That was one of the premises on which we made an investment. We wanted to make sure that we had the right to major decision-making, which is common here. But certainly with respect to major issues, such as the disposition of collateral or a change in financing, which is one of the issues we say triggered a major decision here. We were the largest investor, and we negotiated for the right to have a construction consultant. Well, the sum total of what they're saying is that you negotiated for all of this transparency, but we don't actually have to abide by any of those contractual obligations. And as long as we do so in a way that prevents you from having the very information that you bargained to have in making your decisions, in relying on, in exercising the discretion to make new capital contributions, or to exercise rights with respect to approval, which our client had, with respect to construction financing, or whether they were going to call their equity right to get out of this.
When you talk about construction financing,
Yeah.
the record or the documents make clear that the sponsor, not looking at the initial, but the subsequent capital contribution, the sponsor can't put in capital contribution with monies other than its own money. And in this case here, me drawing your flow chart because you got so many companies here. It wasn't the sponsor's money, but it was the sponsor's, it was Control, which is sort of 60%, 64% owner, that sold some of its interests to get the money and then give it to the sponsor. So you covered yourself in saying, okay, you sponsor can only use your money to make capital contribution, but it didn't extend to the sponsors, subsidiaries, or majority owners, or whatever you want to call them, in terms of what they do.
Respectfully, that's not correct. If you, of course, we all know you read contracts in context of which they are.
Eyeballs are spinning.
I'm sure you're familiar with the rule.
We all are.
And if you look at 2.0 as to what the intent of the parties is, every single provision is pointed at making sure that the sponsor has their skin in the game.
Correct.
And what it says is no financing from third parties. It doesn't.
To the sponsor. What about to the sponsors, the people that own the sponsors? Like I said, the 64% owner, which is Control, and the 30, and on the flip side, 36% owner, which is the manager, of which you guys only own 10%. You guys are so the way I figured out this flow, you guys have very little control as to what's going on here for $70 million.
But not with respect to this issue. So respectfully, what you're talking about is the word indirect. Direct versus indirect.
Okay.
And this provision of 2.A2 is not qualified by the word direct or indirect.
But it's qualified by not even qualified, it's stated very specifically, sponsor. Do you have anything else in there that says sponsors or any of its subsidiaries or parents and so forth and so forth?
Well, the other provisions actually, yes, they do. And in fact, they're required under A3 to disclose to us not just if they sell equity of direct or indirect. So I would submit, why would that be necessary? It must be read in conjunction with 2.8A2
we deal with enough
because we want to know if you did this indirectly as well as direct.
We deal with enough contracts that there are reasons why contracts, for whatever reasons, what they state. And for us to now, for you to argue, well, if the next paragraph says this, you can extend it, and by logic, it has to be applied to this paragraph here. That's almost like rewriting the contract.
Well, what it is it's looking at the language adopted by the parties in light of similar language adopted with respect to neighboring provisions. And if they had meant to limit and qualify this to direct, because the whole point is you can't use money of third parties. They got to use their own money.
I'm not disagreeing with you. I totally agree with you. They got to have a skin in the game. For $70 million, I want to make sure you got a skin in the game.
And they can't end around that by just saying, oh, well, I'll have the third party actually just reroute the money to one level up, and then they'll give me the money. The point is that the ultimate source of the funds that are given to sponsor, and we know that's what happened because sponsor claimed credit for it. Sponsor said, I've met my capital contribution, and they did so with third-party money. What they're saying is that the fact that the manager is intervening should mean that it doesn't matter. In other words, they can end around the skin in the game requirement altogether. That would be clearly contrary to the intent of 2.8 based on this text and the surrounding provisions, and we don't even know where the money was wired. We do not know if it was even given to manager as opposed to the third parties giving it directly to sponsor. So we don't know if the third parties gave it to sponsor.
We're still dealing with 3211, correct?
That's right.
The sufficiency of your complaint on the fourth go-around. I'm overly simplistic, but you get the point. So dealing with the fourth go-around.
Yeah.
The issues on appeal for us now is whether you believe you've sustained a claim for breach of contract referable to 7.5 of the JVA, correct?
That's correct.
And whether you have a separate cause of action for fraud, at least against White and Phillips, putting aside how all the prior causes of action were thrown out based on insufficiency of the pleading. Is that the essence of what's before us now?
That's the essence, and it is subject to notice pleading, and if there is an ambiguity in the contract, that is not for adjudication even on 3213, certainly not on 3211.
You got rebuttal time.
3212, I'm sorry, 3212.
Great. You have rebuttal time. Thank you.
May it please the court, Elon Dobbs for the sponsor defendants. I want to point out.
So what is this indirect, direct funding course about having the sponsor to have a skin in the game? And what happened here was that the sponsor, the capital contributions, it was the parent, I guess, or whatever, that got the more investments.
I want to be precise here. In section 2.8, there are, it makes a distinction between two types of capital contributions: initial capital contributions and other capital contributions. And for the initial capital contributions, it says, and all initial capital contributions made by sponsor to the company have been funded by sponsor out of personal assets and resources indirectly contributed to sponsor.
That's not the problem. That's the second one.
And so,
that goes to why.
The point is,
if it's indirect in one paragraph, why we didn't put it in the next one?
What they're saying, and they said it on the previous appeal on which you sat on the panel, Justice Shulman. They said, as long as the money made its way to sponsor, it violated Section 2.8, but that's not what Section 2.8 says. It makes the distinction. It says for the initial funding of the project, the money has to come by personal resources indirectly contributed to the sponsor. The next one doesn't say that. The next provision, the one that they allege that we breached, does not say that. It says all capital contributions made by sponsor to the company have not and will not include any capital contributions to sponsor from third parties or managed funds. They added 3 allegations to the complaint, and those allegations basically say that Control got money by pledging some of its equity. That's at most, a contribution to control, not to sponsor. The parties knew how to say that money can never make its way to sponsor unless it comes out of the personal resources, the principles of sponsor. They said it right in the provision directly preceding the one they say we breached, and they didn't say it there. And so it elides the distinction between the two provisions in the complaint. I want to, in the section 2.8, this court recently issued a decision in a companion case, and Justices Gesmer and Rodriguez were on that panel, and it decided in that case that that the lower court correctly determined, based on the order that is on appeal here, that there was no claim for breach of sections 8.5 or 7.2 of the agreement, and it's completely clear that this court affirmed effectively and said that Justice Cohen was right to have made a decision that in this case there was no claim stated for Section 8.5 or a breach of Section 8.5 or Section 7.2. And in their reply brief, to their credit, plaintiffs acknowledged that, and they say they want to be able to appeal that ruling to the Court of Appeals. But
what about their claim that they sufficiently set forth the 7.5 breach, that you didn't comply with the provision that specifically, and the Supreme Court said about shall commercially reasonable, but there are two duties in that provision, right?
So that section 7.5 says that
we know what it says, but what do you
No,
respond
I
to
understand that we have to cooperate with the construction consultant and allow them to get copies of minutes and things. There are two allegations that refer to Sterling in the complaint, and one of them says that a sponsor misrepresented the remaining cost of construction on each occasion they shared loan requisitions with Sterling. And the other one says that the requisitions were also sent to Sterling to fulfill sponsor's obligation under Section 4.2AX of the JVA. And the rest of what they fall back on in their brief is they say, well, in the third amended complaint, we had allegations that were detailed that dealt with our lack of cooperation.
Let's not look at that.
So,
let's just look at the fourth.
In our view, this notion that there were documents that were sent to Sterling that contained misinformation, or which are effectively the basis of other of their breach of contract claims and other of their fraud claims, doesn't give any notice
but they specifically have in their complaint, I don't know, paragraph 345, I forget where, that they specifically said that your client, the manager, failed to cooperate with their construction consultant. Flat out says that. And assuming the truth of that allegation, what do you got in response to that?
There must be underlying facts in the complaint. They're still required to plead underlying facts. It's conclusory to say that we didn't cooperate and therefore we have a cause of action. There needs to be some fact in the complaint alleging how we did not cooperate.
Well, that's where you then go back and look at the four corners of the complaint. You look at all the allegations holistically as a whole, right? Because I'll tell you what's going to happen. If we agree with you, let's say I agree with you, and I think it should be dismissed, instead of a fourth amendment, you're going to get a fifth amended complaint, including the third amended complaint's allegations that weren't included in the fourth amended complaint, in a fifth amended complaint.
I have no doubt that that's true regardless.
Oh, yeah.
But that's not...
We could take that to the bank.
But unfortunately, I think that's true. But this complaint, you need to evaluate the allegations that are actually in this complaint. And in our view, and it's in our brief, those don't set forth any failure to cooperate.
Counsel, I'm just curious.
Yes.
Was this project ever completed?
Yes, the project has been completed.
It's been
so the building's up, tenanted, all good?
All of that, yes, Your Honor. We'll rest on our brief if you have nothing further.
Thank you.
Thank you. I just want to pick up where we left off on the cooperation clause. Again, it's notice pleading. We allege, it's 321M, by the way, it's on 107. And
keep track of the paragraphs.
and it says that it was, we give the specific provision that was violated, of course not necessary when you attach the contract, and we say that they failed to cooperate and share information with the consultant, that there's only so much interaction with the consultant. So when we're talking notice pleading, I think they're on notice of the events that are going to be the subject of the
The simple
claim.
point of that is that if you have documentary evidence that challenges that conclusory statement, saying, look, I got here all the documents signed by the construction consultant, and all these times that we met with him and consulted with him, and he signed off on everything. Where's this thing that we failed to communicate and cooperate with him?
That's right.
I didn't,
And they didn't
mounds
put
of
that in.
paper, I didn't see it.
They didn't put that in, and of course, the gravamen of our complaint here is that we were getting false information about the project throughout. And when we're talking about 3211 reasonable inferences, of course, our consultant is the agent that we were relying on in order to make decision-making. I think it well exceeds the breach of contract. What we haven't
Well,
talked...
to my point, if I were to agree with the defendant here, your friend here, that just means we're going to replete again for a Fifth Amendment complaint, right? I mean, you're not stopping because you're looking to get back your $70 million at least.
Yeah, it's more than that. And
okay.
And what we're looking to do is just give effect to the contract that we negotiated for, which were the conditions that we made this investment on.
Has the Supreme Court, the lower court, placed any limits on any further amendments to the complaint?
I don't know if they've explicitly said that all further amendments will be foreclosed. There's not a scheduling order that I'm aware of that forecloses amendment. I certainly am not issuing a threat of amendment here. I don't want this to be taken as that. We're looking to proceed. The case is quite old, again, for a number of reasons, and we're looking to proceed with discovery. Discovery has proceeded and is underway with several discovery motions already decided and documents exchanged here.
You want to go down the road of discovery, right?
Right. we want to actually prove
7
the
years
claims
later,
and get
you're
to
still
a result.
waiting for the first EBT.
Right. That's right.
Got it. Thank you.
Thank you, Your Honor.
Rodriguez versus Sewell. Oh, I'm sorry. That's a submit. My mistake. Cousins versus, need my co-pilot. Cousins versus Glover. Best co-pilot around.
May it please the court. My name is Brian Morrissey on behalf of Target Corporation. We submit there is no genuine factual question that Mr. Glover abandoned the potential errand and resumed his daily commute in his private car to his appointment.
Here's the issue that I have with it. He was deposed twice. And the first time he said that at the time of the accident, he had come from the Bronx store and he had started working already when he went to the Bronx store, and he was on his way to the Spring Valley store, and he was, in essence, in the course of employment at the time of the accident. And then he gets deposed a second time, and in that second deposition, it's a totally different, whole new story. So my question is, doesn't that present an issue of fact for a jury to decide?
I think when the two transcripts are read in conjunction, the questions are answered. When he said, was he working, that expressed the intent that he had to perform that errand. And indeed, I would further submit that even if he had performed that errand and gotten the forms, he still is resuming his daily commute.
But he answered the question. I mean, I can read it.
Sure, I
have the transcripts where he says, this is when he is first questioned in his first EBT in January of 18, the day of the incident. Were you working? Yes. Were you doing anything business related? Were you going to a post office? To a post office? No. Were you working but not actually working at the moment of the incident? Correct. Have you begun your day at this point? Yes. What time did what time did your day end, midnight? Incident occurred at 1:30, and then he starts working at 1.
Correct. What that deposition shows is the power of putting words in a witness's mouth. He said yes to a question of whether you're working. That's not necessarily untrue. And I think the second deposition clarified it. And no matter what, there came a point when he got on the highway and resumed his daily commute. And under New York law, I really think...
Right, I think
He was coming, I'm sorry.
the point is you're making is that you don't find liability, vicarious liability, if he's commuting to work, right? There's no vicarious liability. That's what he's saying. He's just commuting to work.
Correct.
Right? What happens here, however, is that stopping off at one of the targets, that sort of furnished the occasion for this type of situation that happened, right? Because it wasn't he wasn't commuting. He had gone to another store to see if they had supplies. They didn't have supplies, so then he now goes back and resumes his commute. True. But there is that in between furnishing the occasion, right? I mean, he didn't just, it wasn't a straight up commute.
True, but first of all, the accident didn't happen when he was doing that 4-block circle route. No. It didn't happen when he was making the cell phone call. A cell phone call in this modern day and age doesn't mean you're engaged in the scope of work necessarily. It's not per se. None of the cases that deal with this type of thing deal with cell phone calls. He could have made the cell phone call from home and still had the idea, maybe I'll stop off. It
That would
doesn't,
be, but that's a different fact.
no, it's a different fact, but my point is that the idea of a 4-block detour on a regular daily habit and a cell phone call does not necessarily infect the whole commute. That's the California cases that we cited in our brief that I think New York does not agree with.
Okay. All right. You have a question? Okay, thank you.
Thank you.
People versus James Glenn.
Good afternoon. Karen Brill with the Office of the Appellate Defender on behalf of James Glenn. I hope to spend the bulk of my time addressing the prosecutorial misconduct point, but I did first want to note that respondent does not oppose our request for your honors to vacate and reduce Mr. Glenn's
Persistent violent felony offender status.
Yes, your honors. Mr. Glenn is now 76. He has no history of violence whatsoever, and he received an unduly harsh life sentence for these commercial burglaries. Unless your honors do have any questions about the uncontested sentence reduction point, I'll turn to the misconduct point.
And that reduction would be to 3.5 to 7?
Yes. It is a basic principle that in a trial on multiple charges, a jury cannot deliberate in the aggregate, but instead can convict on any given charge only when that charge rests on sufficient evidence. And our system likewise prohibits a jury from using the number of crimes a person is charged with as proof of their guilt. These are foundational requirements of a fair trial that the prosecutor betrayed in Mr. Glenn's trial on 12 different burglary counts when he explicitly told the jury that if this was one incident charged alone, quote, that is not proof beyond a reasonable doubt, but then continued, quote, at what point, at how many incidents do you need before it's clear as to what happened? That's a propensity argument, and it was just one of many pieces of a pattern where the prosecutor directed the jury to consider Mr. Glenn's guilt not as 12 questions, but as one single blurred question. The prosecutor also repeatedly referred to the evidence in the aggravate, calling the burglaries one giant web that Mr. Glenn was trapped inside, and perhaps most egregiously, invented a supposedly unique modus operandi to link all of the burglaries together that did not, in fact, exist. All the actual evidence of a pattern that linked these different burglaries together was that Mr. Glenn went into buildings from which laptops went missing. Absent any actual unique modus operandi that distinguished these from the ordinary, the jury had no basis to...
The ordinary what?
From the ordinary way of committing any laptop theft. I think...
Well, wasn't he sort of like wearing the same type of clothing, had fake IDs on him. In essence, went into these premises and looked, tried to open doors. And he was even stopped, I think, trying to enter one of them. And he showed his ID, which obviously was fake. But that's why he had it, so that if he got stopped, he would be able to, in essence, fool whoever stopped him into believing that he was either a technician or he was a messenger. So, and that happened throughout.
So I do want to correct, Your Honor. The ID was found in his apartment afterwards. There's no evidence whatsoever that he ever showed the ID to anyone during the burglary. But that's exactly actually what the prosecutor told the jury in summation, and I think that's the problem. The prosecutor made it sound like that in each of the burglaries, Mr. Glenn, quote, played characters and used ruses. In fact, there was no testimony at all that anyone ever mistook Mr. Glenn as a messenger or a computer repairman, or that he affirmatively represented himself as either role in any way.
But part of what the prosecutor was arguing with regards to the modus operandi was that the defendant wore clothing such that the design of it was so that he could blend into the workspace, right?
So Mr. Glenn's identity as the person in the building was never in...
It's not about identity. It's about him fooling others into believing that he belonged in the workspace.
Understood. So I think the fact that Mr. Glenn was wearing professional clothing in an office building did not distinguish him from one of the many other people in the office building who could have committed these thefts, and that's what the modus operandi needed to be probative of his identity as the person who took these laptops. I would also just note that even if Your Honors think this is a unique modus operandi, there's still reversible misconduct here because the prosecutor egregiously misadvised the jury as to that very narrow exception. Had the prosecutor sought an admissibility ruling under Molyneux, this evidence could have come in with correct limiting instructions, and there were two important limits that needed to be put before the jury here. The first is that in order to use the modus operandi exception, a jury must first find sufficient proof of one incident before it can use that incident as proof of someone's identity of a second. That's exactly the opposite of what the prosecutor told the jury, which was that in no case was there proof beyond a reasonable doubt, but it could still use how many incidents there were to resolve that doubt.
Counsel, in this case, the defendant represented himself, correct?
Yes, Your Honor.
And in large part, the prosecutor's summation was an attempt to deal with the defendant's argument that all this was a conspiracy against him. Weren't the prosecutor's comments in summation fair response to the defendant's argument that this is one giant conspiracy?
That was respondent's argument with respect to the parts of the prosecutor's summation that went to calling Mr. Glenn a conspiracy theorist. But the idea that these burglaries could all be considered together as one giant question was not responsive to anything in Mr. Glenn's summation. It was independent misconduct that requires reversal. It went to the heart of the case here, where 12 different, and I see my red light is on, if I could finish my thought.
Well, you have reply time.
I'll save my time. Thank you.
Good afternoon. May it please the court. Rachel Bond for the people.
So how do you respond to your adversary's argument that the prosecutor's summation impermissibly put all these things together and used the propensity argument?
So there are two responses to that. First is that the prosecutor went through the evidence as to each charge individually before he began talking about the aggregate of the evidence as to all 12 burglaries. And additionally, beyond what the defense picks out in their brief as the main quotation, he continues. After he says, how many incidents do you need before it's clear as to what happened? He says, you don't just have the defendant on video and laptop goes missing. We know that defendant sells these stolen laptops. We know he goes into businesses with fake IDs. He says there's no other explanation as to why he was in all these spaces. So he is creating an argument here that the defendant presented a unique modus operandi to commit these burglaries. And he doesn't tell the jury that they can convict based on all 12, just based on the sheer number. He specifically goes through the individual counts. Additionally, the prosecutor didn't, I wanted to say to begin, the prosecutorial misconduct claims are not preserved to begin with. The defendant didn't object to any of these below. But beyond that, the prosecutor didn't invent a modus operandi, and it is not misconduct to argue the prosecution's theory of the case. The evidence of each burglary was admissible here to be corroborative proof of defendant's identity as the perpetrator of the other burglaries. They were properly joinable and were all tried together. The prosecution did not need to make a Molyneux application for that. And under Everett, it was entirely proper for the prosecutor to discuss the modus operandi in the way that he did in his
Well,
summation.
how about the lesser included offense argument? It's a criminal trespass, should have been charged to the jury.
Sure. To begin, third-degree trespass is not actually a lesser-included offense of third-degree burglary. Although the lower court found that it was, the Glover test is a single multi-pronged legal ruling. And so under Garrett, this court can decide that it was not error based solely on that prong alone, that it is not actually a lesser-included offense.
And why is it not a lesser included offense? Because the elements are different?
Yes, under Santiago, which this court decided, and Moore, which is the Court of Appeals, it's been explained that one could potentially commit third-degree trespass because it includes that fenced or enclosed to exclude intruders language, whereas third-degree burglary does not necessarily include those kinds of buildings. But in any event, even viewing the evidence most favorable to the defense, there was no reasonable view of the evidence. The defendant meant only to trespass and not commit some other crime in the building. It is extremely obvious from his conduct on the videos that he was there in those buildings, casing, looking for things to steal, and eventually found empty offices where he could take the laptops. And if there are no further questions, we rest on our brief and ask that you affirm.
Thank you.
Thank you.
So I think when respondent talks about the strength of the evidence, she in a way repeats the error below, which is to look at all of these cases in the aggregate. The actual harm of what the prosecutor did below is that there are wildly different amounts of proof in each case. In 9 incidents, there's no link between Mr. Glenn in any laptop. In 6, there's no video of Mr. Glenn in the actual company itself, as opposed to the much larger office building. And as I raised in my sufficiency arguments for counts 2 and 5, in those counts, there was not even a complainant who could say that the laptop was still there by the time Mr. Glenn went into the building, because they didn't know when their laptop was stolen within, in one case, 2 weeks, and in one case, 5 days. So you have incredibly different levels of proof here that are bolstering each other. And that went to the heart of the case here. Where you do join 12 cases together, there's inherently a huge danger that a jury will use propensity of how many charges there are instead of sorting through the evidence. And we know the jury did that given the length of the deliberations here, which was 3 minutes long. I did the math in my brief, but that's 15 seconds per count. It's clear the jury did not deliberate independently on each case. Given that the prosecutor did use this pattern to lump all the cases together and to deprive the jury of its duty to consider each case's evidence separately, we ask your honors to reverse in the interest of justice on that count.
Thank you.
Thank you.
Madison Square Garden versus New York State Legal Authority. Justice Rodriguez is recused from that matter. Just so you know the rules, if there's a tie, in the event there's a time, a 5th justice will be vouched in, and we will proceed according to the rules of the First Department in that regard.
Thank you, Your Honors. Randy Mastro of King and Spalding for appellant petitioner Madison Square Garden. Now, Your Honors, I know the hour is late. It's been a long day. We're the last case. But
we did it pretty good. It's only 4 o'clock.
You did great.
Well, Mr. Mastro, since the hour is late, let's cut to the chase a little.
Yes.
There has been no exhaustion of administrative remedies here. Would you agree with that statement? Has a single license been pulled from any of MSG's property?
Your Honor.
Yes or
there
no?
has been no exhaustion. And
there's
the reason
been no
for that,
I'm sorry. There's been no evidentiary hearing that has taken place yet, as far as this record is concerned.
Your Honor, that is also correct. But
Your argument is there should be no hearing at all because they don't have jurisdiction.
Correct. And Your Honor, this is a case of a gross abuse of power by the state liquor authority exceeding its statutory authority by threatening to revoke Madison Square Garden's liquor licenses, and it cries out for judicial
I don't know if
relief
you should
right
use
now.
threaten to revoke. I mean, they're just doing, I mean, on its face, they're doing what they're authorized, what they're purportedly authorized to do is that they got a complaint. They didn't initiate this on their own. They got a complaint from somebody saying that they were being excluded from one of the venues, right? I mean, did that happen or not?
Yes, one of the plaintiff's lawyer firms affected by the venue policy. Now, let me try and clarify why there should be no exhaustion requirement in this case, and why I think the law is clear in that regard, because we're seeking a writ of prohibition under 73032.
Yeah.
And a writ of prohibition.
We get that. You want them to, you're just, and the basis of that writ of prohibition is they don't have jurisdiction to hear this.
Correct, and let me explain why.
Why?
Thank you. Thank you, Your Honor.
We read the stuff. We read the stuff.
We really have cut to the chase.
Yeah.
I'll explain why. Because they purport to do this on the pretext that they have the statutory authority to determine whether Madison Square Garden is a bona fide premises generally open to the public. That's the standard they purported to apply. And they have an administrative rule to that effect. Let's talk about what the statute actually says. What the statute actually says is it never once uses or authorizes the SLA to determine whether any licensee is a bona fide premises. It only once, in a separate section applicable to restaurants, talks about them being open to the public, because of course, bars and restaurants are places of public accommodation where people can walk in off the street and you are supposed to be able to get served when you walk in. Madison Square Garden has a liquor license under an entirely separate provision of the statute. It has a liquor license under 64A, which is for special venues, meaning privately owned private entertainment venues that obviously are not places of public accommodation under longstanding New York common law.
Certainly places of public accommodation under, for example, the civil rights laws. You couldn't not sell tickets to somebody based on their race. Would you agree with me?
I would agree with you completely, Your Honor, but let me explain the difference. Under 100-year-old New York common law, private entertainment venues, and this is a special permit to such a venue, okay, that says nothing about being open to the public for good reason, because under 100-year-old New York common law, a private venue, entertainment venue operator has the right to revoke tickets or deny admission for any reason or no reason at all, unless there is a statute that expressly and unambiguously and clearly says they can't. There's no such statute
I thought
in this
about
place.
that. I thought about that in terms of there's a tension here because, well, a seeming tension because you got the civil rights laws that gives you the power that you say that you have, right? And we've already ruled on that.
Correct.
And then
This
you
court has
have
already
the
ruled we can
and you
deny
have the
people
liquor,
access.
and then you have the ABC law that's out there that's very comprehensive. And you're saying that, the specific or special, the particular license that my clients have received here doesn't have this open, open
Correct,
to the
Your Honor.
public analysis here. But why is it then, can't we, according to like my colleague said, you go ahead and have it, and then you can, and then that's a finding that they're going to have to make. That's going to be challenged at that proceeding that you don't have this here.
I'm glad you asked that, Your Honor, because you have cut to the chase. Okay. It's not in the statute as to 64A, yet the state liquor authority already wrote to Madison Square Garden and said, here's our guidance. We're putting you on notice. This is in page 109 of the rec. We're putting you on notice that you're not open to the public because of this policy, okay? And you could face consequences. It then has said to court after court, it has said, there's no factual dispute here of what's going on, and it has said specifically that it issued the disciplinary charges. I'm quoting the SLA in its motion to dismiss brief below. It issued the disciplinary charges because MSG was not following the SLA's guidance and instead was continuing to enforce its adverse attorney policy. And it went on to say, as a result, we could revoke your license. They have said to this court, we could have a hearing and we could determine how extensive the penalty should be, whether it's revocation or something less. But our point is more specific.
Or determine, if they accept your argument, that you have the right to do what you do at the end of the hearing.
Your Honor, they've already made clear with statements
No.
like that.
The letter is posturing. It doesn't mean anything right now.
I'm not
Obviously,
talking
you have due
posturing.
process rights.
Your Honor, I'm not talking posturing. I'm talking what a state authority actually said to Justice Engoron below. It said that you didn't listen to our guidance, so we charged you with the offense. And now we're going to pursue penalties up to license revocation. You don't have to doubt that. It's their words.
But
they can't deny it.
But there's a prosecutorial arm in the agency, and then there's an adjudicatory arm. So whoever files the charges is not necessarily the one that's going to be deciding whether or not those charges were appropriate and whether or not your license should be revoked. There would be an administrative law judge deciding that.
I appreciate that Your Honor asked that question, because we also established in this record that over 90% of the time, the prosecutorial arm and the SLA administrative judge for the tribunal, he's an employee of the SLA. He can only make a recommendation. He can't actually dismiss charges. That's their rules, okay? It goes to the SLA board, all right? There's no question here that this guidance was issued. General counsel's office, head of the SLA, he's now been kicked out, the head of the SLA. Hopefully, that means a better day at the SLA. But Your Honor, over 90% of the time, when they start that administrative process and there's a recommendation, a finding of violation, over 90% of the time, the SLA board rubber stamps that. And Your Honor,
Maybe that's because they prosecute cases that have merit.
well, maybe, Your Honor, this case is so obviously
For
lacking
example.
in merit, because who could possibly say, who was a reasonable, objective trier of fact, that a venue policy that affects a few hundred attorneys, that's less than a fraction of a percent of all the attorneys in New York, less than a fraction of a fraction of a percent of all the people who attend
I have to tell you,
MSG.
Counsel, I'm a little concerned about agreeing with that analysis, because today it's attorneys, tomorrow it's judges, then the next day it's going to be police officers, next day it's going to be firefighters. I mean, just by that, I mean, that's a concern I have, you know? I mean,
Your Honor, I don't ask you to like the policy. I don't ask you to endorse it. It's the law in this state for over 100 years. That Madison Square Garden has a common law right to make decisions to exclude
we're
for
beyond
any
the common,
reason
but
or no
counsel,
reason
but
at
we're
all.
beyond the common law, because we do have a statute, a direct statute that addresses alcohol provisions in the state.
Your Honor, please take a look at Section 2. That's the policies that the state legislature said the state liquor authority is to enforce. What are those policies? Do they have anything to do with being a bona fide premises or open to the public? They have zero. They have zero.
But it's very broadly worded.
I will tell you exactly what the provisions are.
We know it too, it's okay.
All right, it's all right, but it talks about promoting temperance. It talks about regulating the distribution, sale, and manufacture of alcohol. It talks about the health and safety and welfare of New Yorkers. I haven't heard that making sure they can drink a lot is part of health,
try to
safety,
say that you're
welfare.
excluding attorneys for their health and well-being, so they don't drink in your premises?
No, Your Honor. The exclusion of attorneys has to do both with protecting the integrity of the litigation process and
I mean, isn't that the job of the courts to protect the integrity of the? I mean, that's very kind of Madison Square Garden to step in to help the courts maintain the integrity of the courts, but I think that's our job, not your job, isn't it?
Your Honor, but that has nothing to do with the state liquor authority's statutory authority. And let me say this. Let me say this, please.
You're saying the reason you can do this is because you want to maintain the integrity of the court system. That's
No, Your
What
Honor.
gives you the authority to do that?
No, Your Honor, I'm saying that we have the right to do this because there's a 100-year-old common law right of a private entertainment venue operator to exclude for any reason or no reason at all.
All right, counsel, you have rebuttal time. Thank you.
Okay, thank you very much, Your Honor.
You bet.
Good afternoon, and may it please this court. Anthony Raduazzo on behalf of the state respondents. This court should reject petitioner's attempts.
So let's get right to the heart.
Go ahead.
I'll let you.
Go
You're
ahead.
going to ask the same question. No, you do it better.
Go ahead.
So he's saying that the license that his client got has nothing in there that talks about open to the public, and that what you're doing is clearly in excess of your jurisdiction, so that we should grant this writ of prohibition and stop this right here now. What's your response to that?
Sure, several responses to that. They rely on an exception from the Watergate 2 case in their argument that they don't need to exhaust administrative remedies here, but the Court of Appeals has been clear that that exception only applies where a petitioner has credibly alleged that an agency has wholly gone beyond its jurisdiction. And here, petitioners have made no such allegation here. It is
That's what he's claiming, is that, that's exactly what he's claiming.
Yeah, I'll explain, Your Honor. It is undisputed here that petitioners hold retail liquor licenses that were issued to them by the Liquor Authority. It is also undisputed that the Liquor Authority has a jurisdiction to regulate and revoke liquor licenses. Now, petitioners here, they are not challenging the rule directly. They're challenging the decision to charge them under Rule 53.1D. That is a charging decision, but there is no dispute here that the Liquor Authority has jurisdiction to initiate administrative
That's the whole point that they're making. They're saying the charging of the petitioner has to have a basis. And they're saying, where if you look at the Section 2, where's the basis of it? Because it doesn't use the word, specific words, open to the public as the other provisions say, so that you don't have a basis to even charge me.
Yeah, several points on that. So I think the statute here, most clearly in Section 118, creates a regulatory scheme in which individual licenses are issued only for specific purposes. Right. And Rule 53.1 gives life to this aspect of the statute because it requires someone who gets a license for one business purpose to continue using it for that business purpose.
That's the regulations that flow from the statute, right?
Exactly right. And as applied to on-premises and special on-premises licenses, that requires venues to be open to the public for several reasons under the statute. One, the statute explicitly states where particular type of venue can be closed to the public. So there are several provisions here. Catering establishments is one, social clubs is another, restaurants at the 1964 World's Fair is another.
So what you're saying is, what I'm understanding is that the statute may not have addressed it, but the regs that we implement as a result of the statute on the rulemaking authority, we do address it.
That's correct, Your Honor.
You've been doing it for decades.
Yes, for at least 60 years, Your Honor, and this is clearly a reasonable interpretation here for the reasons I just mentioned. But I'll also add, petitioner's entire argument on this point rests on the notion that there's been an abrogation of common law, but that's simply false here.
I actually wanted to ask you to address that. Their argument is that the common law says that they can exclude somebody or anybody, and for them to exclude a few random lawyers doesn't really affect their openness to the public or anything else.
Yeah, exactly. So petitioners here, I will say, they are free, subject to the civil rights laws, to reject whoever they want. They can exclude whomever they want from their venues, but they can't do that and continue to sell alcohol at retail for on-premises consumption. That comes with certain...
Pick one or the other, basically.
You have to pick one or the other. That comes with certain conditions attached.
So they could stop selling liquor and not allow any lawyers
That is exactly right, Your Honor. Having a license under the alcoholic controlled beverage law comes with certain conditions. And they admit in their brief that selling alcohol is not a common law right at common law here.
Can I move on to something else
Yes.
I'd like to move on to something else.
Certainly.
I couldn't find the statutory basis for SLA to issue an investigatory subpoena. In this context, when there's been no hearing yet.
Pre-hearing.
And also putting aside whether the kind of information you're seeking is really relevant to dealing with the violation you believe exists under the license law. Do you understand what I'm saying? There's no notion under these circumstances to have issued that subpoena. I don't understand the basis for it at this time.
Just to clarify, Your Honor.
Putting aside whether the judge, whether there was a basis for the judge to have looked at any of the documents in camera and determined what's in and what's out. Putting that aside for a moment, I don't understand that.
Just to clarify, Your Honor, are you referring to the discovery dispute? That is the second dispute? Yeah, so
Isn't that part of this appeal?
I believe that was.
They moved to quash the subpoena.
I believe that was submitted, Your Honor. There was no request for oral argument by the other parties here.
No, it's a good question to ask.
In any event,
stuck with the
Rule
question.
54.4 under the Liquor Authority's rules does allow them to seek discovery. Both parties are allowed to seek discovery, Your Honor. I believe that's the basis for the subpoena. If I may briefly discuss.
I'm sorry, before a hearing is commenced, before a proceeding is commenced?
Yes, while the charges after the charges have been initiated before.
Wasn't the subpoena here served before the charges were?
I believe that's correct, Your Honor.
So what is the authority for that?
I'd have to get, I believe, again, this issue was submitted.
Okay, got it, sorry.
I'll rest on the briefs on that issue, Your Honor. Just to briefly touch on finality, I will note that the only costs that petitioners here, or the injuries, excuse me, that they rely on here are alleged reputational harm and the costs associated with participating in the process itself. But it's well established that the mere initiation of administrative charges is not a cognizable legal injury for purposes of finality here, and that's for good reason. These costs are inherent to every single administrative proceeding, so if the reverse were true, administrative charges would be immediately appealable in every single case. Furthermore, petitioners acknowledge here that they have only challenged one of the 4 charges against them. So even if this court agrees with petitioners' claims, that wouldn't stop the administrative proceedings from going forward, which means they can't demonstrate that the pending Rule 53 charge would harm them in any way. And briefly on exhaustions, as Your Honors pointed out, petitioners here will have a full opportunity to raise their legal and factual defenses, both before the administrative law judge, before the full Liquor Authority Board in a separate proceeding, and in the event of an adverse determination in an Article 78 proceeding before this court. This is
Which concludes their jurisdiction argument, but in this case, it's sort of like a preemptive strike that we don't even get. I mean, he's asking for us right now to decide the jurisdiction issue before even the administrator. Like it or not, the administrator may agree with them and say, you know what, we don't have jurisdiction.
That's correct, Your Honor. And I will point out that the statistics they rely on here show that this is not a futile attempt. The agency dismisses charges in 1 out of every 3 cases. That doesn't even account for the cases where charges are sustained, but the agency selects a penalty other than license revocation. Your Honors, this process could result in this, although all the legal issues presented here being entirely academic or moot, and for that reason, there is no finality, there is no exhaustion, and this court should dismiss the petition.
Thank you.
Thank you.
Justice Gasmer, you asked a very important question, and the answer that he gave was Madison Square Garden has the right to exclude for any reason or no reason at all, consistent with the civil rights laws.
If it chooses not to have a liquor license, if it chooses not to have a liquor license.
This is where this.
Okay, but it seems to me that what counsel laid out, I thought pretty clearly, was you can exclude anyone you want if you want to give up your liquor license, but if you want to keep your liquor license, then you have to follow their rules. So why is that analysis
A license
not
is a
correct?
privilege, not a right.
Yeah, you can't claim a common law right to a liquor license.
Actually, a license is a property right once you have it, and have it taken away involves both substantive.
Well, that may
and
be,
procedural
but
due
it doesn't,
process.
it's not under the common law.
This is the process that we're in.
Yes, but Your Honor, I was coming to your second point because he didn't cite you any statutory basis. He cited you to their regulations.
Which is part of rulemaking authority. You have a statute and then you have rulemaking
Your Honor
authority.
only has rulemaking authority to the agency only has rulemaking authority to the extent a reading of the statute empowers them to pass rules about being open to the public.
But you know, with the rulemaking authority, so if I understand it here, it's put out there for consumption for folks to look at and everything. And if you believe that that rulemaking authority is beyond what they're allowed to do, that's where the challenges come in. But this rule or this regulation has been in existence for, what, 60 years, decades?
And let me come to that. Each example of application of this rule that only says you have to be a bona fide premises, and it's not otherwise defined in the rule. Each of those cases involved a bar or a restaurant. Each of those cases involved an either exclusion of a huge portion of the population, one of them was Chinese only, One of them was, not allowing anyone but women. Or you have a license, a permit.
So, Mastro, that's an interesting point. If they only excluded one woman because she was a woman, to carry your thought, because you're using a quantitative analysis, the group of lawyers is only 0.1% of the population, which means they can't be excluding the public. Would you say that's permitted to do that? Yes or no? Would you
Yes.
say based on what you just
The answer is
exclude
yes.
one woman?
Yes, the answer is yes, unless it violated the civil rights laws. The answer is yes, for the following reasons. Okay?
But you just said the civil rights law allows you to exclude anybody you want.
Yes, I'm saying if there were a civil rights law that protected gender discrimination, that would be a different issue. But
Well, that's what I just asked
you asked about one woman. I think
But
that
I
they have the right
use
to exclude
quantity.
one woman.
You claim they can exclude lawyers who are engaged in litigation for whatever reasons, and I understand
Your
it.
Honor,
So I'm asking you, would you say that your client would be allowed to exclude one woman because of gender, because they don't want a woman in there?
Yes, unless it violated the civil rights law, okay? But the point I'm making about these other cases, as they've applied them over those 60 years, is it's only been when the particular bar or restaurant, not private entertainment venue under a different section of the statute, 64A, a bar or a restaurant decided to exclude a whole class of people or not admit hardly anyone because they operated more like a private club. That's how this rule has been applied over 60 years.
But does the
It's
rule
never been
say,
applied to
excuse me,
Madison
does
Square
the
Garden.
rule say anything about quantity? Does it say how many people?
The rule,
I gather the rules, the rule says that he can't exclude a category, but if it's a small category, that's okay?
Your Honor, the rule simply says being a bona fide premises, and how the SLA itself has applied its own rule, which we say is beyond its statutory authority to have adopted in the first place. But he says it's been there for over 60 years. They have never applied it to a circumstance involving such a limited policy of a private entertainment venue like a Madison Square Garden that has a special license where people have to buy tickets to get in and can be excluded under longstanding common law for any reason or no reason at all. They have never applied either the regulation or the statute to say that you weren't a bona fide premises not open to the public when you're a private entertainment venue, you sell tickets, and you have the right to revoke those tickets at any point. It's obviously not the same as a bar or restaurant because not everybody can get in. They have to be sold a ticket.
All right, thank you, Mr. Master. We got it. Thank you very much.
Okay, Your Honor, one last thing.
No, we got it. Come on.
Justice Shulman, thank you for pointing out and Chesmer, the problems with their subpoena. There is no reg that lets them.
We didn't point out any problems, we asked questions.
I understand.
Thank you.
I
Thank you.
understand. I understand. Thank you. Thank you. Thank you. Appreciate it. Thank you.